Welcome to CIVICA, the European University of Social Sciences.
Hello and welcome to a new episode of Voices of Civica. Today we are here in Bocconi University. My name is Lorenzo Bassani and here with me we have Elisa Maria Restani. Today we have the honor to speak with Professor Chiara Graziani, who is assistant professor in Bocconi University. She holds the courses of comparative public law, Italian public law, Italian and Anglo-American constitutional law, as well as citizenship and migration law. So thank you for being here, Professor Graziani, and I would like to first ask you about your research efforts. What are the topics you are doing research now, and which are the ones you did research in recent years?
First of all, thank you for this invitation. Well, my topic of research concerned the use of technology in a set of regulatory issues, starting from the regulation of digital platforms in general, to focus more in the topic and in the field of counterterrorism, national security, and other security-related issues. I have investigated the relationship that exists between national security, public security on the one hand, and the protection of human rights and of other rule of law related issues. So this is my topics on which I focus from a perspective which is a comparative perspective, as you also mentioned. So I focus on the European Union, but also on how these things are implemented by member states. And we know that when we talk about digital technology, we have to refer as well to the United States and other global actors.
Thank you. So talking about technology, in the past years, the European Union passed a series of pieces of legislation, such as the Digital Services Act, the Digital Market Act, and the AI Act, which on paper at least, aim to regulate the market of digital services. However, some critics see these measures as limitations of freedom of expression, especially on the web and on web platforms. Well, what is the subtle line between the regulation of digital platforms, processes, and the freedom of speech limitations? How do you see this trade-off? Which are the boundaries?
Okay, well, we have to start by saying that all the pieces of legislation that the European Union has passed in recent years, they are all very relevant to that question, but they need to be a bit differentiated regarding their scope and their purpose. Starting, for example, from the Digital Markets Act. The Digital Markets Act is primarily a market regulation tool. It addresses the economic powers of so-called gatekeepers, and it tries to make digital markets more fair and also more contestable. It's not directly related to speech regulation, but to market structure, access to market, interoperability, which have an indirect effect of the regulation of speech. Then we have the Digital Services Act, and the Digital Services Act, in my view, is closer to the problem, or let's say it's more directly close to the problem of freedom of expression, because it regulates the responsibility of online intermediary, including platforms, of course, and specifically with regard to illegal content, disinformation, but also notice and action mechanism, and also, let's say, how the algorithmic aspect of these systems work. So it does not just simply say to the platform which kind of speech needs to be removed. It rather creates a procedural framework for how the platform needs to govern the content and the risks that are associated to content. Then we have the AI Act. The AI Act, it's not stricto sensu a platform regulation act. It's more a risk-based system for artificial intelligence, and its central concern is the protection of public interest, and in order to do this, it classifies AI systems as non-permissible, high risk, lower risk, and so on and so forth. This affects as well, although indirectly, access to information, content moderation, political communication, but also profiling. Think of commercial and non-commercial profiling, and I would say more in general decision-making process. To this framework, speaking of freedom of expression, I would also add another tool, which is the regulation on the removal of terrorist content online. This is a regulation which is very specifically for national security dangerous content, and it requires hosting service providers to remove or to disable the access to terrorist content within 1 hour of the removal order. Maybe this is the clearest example of the tension that we are discussing. So here the EU is not just regulating market processes, it's imposing very rapid content removal obligation in an area which is an area of fundamental rights, security, and overall democracy. So in order to answer your questions, where's the line between regulation of platform, which can be legitimate objective of the European Union, and the limitation of freedom of expression? Well, it's a question to which I don't think there is a single and abstract answer. The line that you're mentioning always depends on measure, on institutional safeguards, and on the effect that they are produced in practice. We know very well that from the European perspective, freedom of expression is not intended in the same way as it is in the United States, for example. In the United States, the First Amendment, it gives very strong suspicion towards the regulation of everything that is speech. While in Europe, of course, we have legal guarantees for freedom of expression. Think of Article 11 of the Charter of Fundamental Rights of the EU, but it's subject to more limitation, balancing, and proportionality review. The key criterion here is proportionality, but sometimes proportionality is, let's say, used a bit like a slogan, and it's not so much put into practice. So what I would like to try to do is to give some guidelines, to give some criteria that implement in some way the principle of proportionality. The first, in order to assess whether a measure is proportionate, is the measure directed at illegal content or at content that are lawful but maybe sometimes undesirable? This is one of the crucial distinctions that we have to bear in mind when we consider whether a public authority, be it European, domestic, or any kind of authority, is intruding too much into the field of freedom of expression. Because requiring a platform to act against something that is clearly illegal is very different, of course, from pressuring a platform to remove lawful political opinions because they are controversial or radical or inconvenient. So this is one first line. Second, the second issue that I consider important in order to check this is who decides. Sometimes the removal order, as for example in the platform regulation, in the platform moderation regulation, sometimes the removal order is an order by a public authority. It's an order with a clear legal basis, which gives reviews, the possibility for review. Other times, the removal is carried out by private platforms. This is possible, but this is a bit more controversial. In those cases, which are made possible under European legislation, what's important is to ensure transparency, internal complaint mechanism, and in case of mistake, also effective redress. So I think that a system in which platforms, they just take the content and silently remove them, it's much more dangerous than a system where you have clear rules and contestable decisions that can be challenged. The third aspect that I see relevant in terms of answering your question is what is exactly being regulating? Are we regulating the speech itself, or are we regulating the system that enables the speech? And this distinction, in my view, is central. The EU often claims that it regulates processes, how recommendation systems work, the transparency of the advertising, the risk assessment, moderation procedures, and things like that. Generally, this is more acceptable than if you take substantive control over opinion. But you can well understand how this distinction is not absolute, because sometimes you regulate visibility or the architecture of visibility of a certain content, and these directly affect public discourse. So these are very sensitive operations. Another criterion that in my view is important is whether the regulation gives sufficiently precise obligation. So you cannot just say to a platform, you have to remove harmful content or disinformation because they are risky. So the more indeterminate the category of content is, and in my view, the stronger procedural safeguard must be. Another issue that's important from the perspective of answering your question on the balance is there a risk of overcompliance? This is very important in the digital environment, because the digital environment is, first of all, a market. So if regulations, they impose very high sanction and very short time limits, the platforms sometimes they may prefer just to remove too much rather than too little, because they perceive this as a risk. And this may produce a chilling effect on lawful speech. So you don't have just to look at the text of the law, but also at the economic incentives that it creates to platforms. And my last point on the principle of proportionality is, are there transparency and redress mechanisms? A system must allow a user to know why the content is removed, why his account has been suspended, or why, for example, certain content have been downgraded. And so user must have access to complaint mechanism, and also I would say to judicial or at least administrative independent review. So these are the criteria that I see important in trying to answer case by case to your question. Generally, the line is crossed, in my view, when platform regulation ceases to be a framework for accountability and it becomes a mechanism of control. I wouldn't say that the European model is anti-speech. It's a model of regulated pluralism. But in my view, its legitimacy always depends on whether EU and national authority, they can keep a certain balance between protecting democratic society from real digital risks, because they exist, without transforming the platforms into private censors that act under public pressure.
After a series of political scandals involving parties across all Europe, including allegations of foreign interference, including alleged Russian funding and propaganda networks, the European Union has been implementing measures to protect democracy and regulate online political advertising. How should this process be carried on? And how should the EU regulate disinformation and political advertising without endangering political pluralism and political debate?
Okay, here I think that the starting point is that the EU, but not even any national, supranational authority, they should not try to regulate political truth, because in a liberal democracy, public authorities, they cannot just decide what is true and what is false in the political debate. We are in a system of pluralism, and pluralism necessarily includes controversial points, exaggeration, and sometimes even harsh or misleading rhetoric. At the same time, of course, democracy cannot remain passive in the face of some problems, like, for example, foreign interference, opaque financing, or sometimes also manipulative online campaigns that, as we know, are encouraged so much by the use of algorithms. So the issue is not to create political persuasion, but to go against non-transparent political influence. And I would say that this is the logic of the regulation that the EU has implemented on the transparency and on the targeting of political advertising. the regulation, the idea behind the regulation is not, of course, to ban political advertising. It's to try to make it more transparent. If you're a citizen, you should know when you are seeing a political advertisement, who paid for it, which election or referendum it concerns, and whether any kind of AI targeting techniques were used. So, in my view, the correct approach is to regulate the condition of political influence and not the substance of political disagreement, which would not be correct. So, public authorities can legitimately intervene, for example, in regulating sponsorship, campaign financing, the use of foreign interference, data-driven targeting, and other algorithmic procedures. It's not a question just of free speech, but it's also a question of electoral fairness and democratic equality. Of course, public authorities, the EU, but in general, I say public authorities, they should be very cautious when the regulation concerns the content of political speech itself. For example, imagine that you have a general power to remove disinformation. This might be necessary, but also dangerous, because disinformation is a very vague concept, is politically contested, and it could easily produce chilling effects, or just, as I was saying before, incentivize platforms to over-remove the content, to over-remove political speech. So the idea is not to censor content, not even political content, but to, again, give transparency, traceability, and accountability. You are seeing a political advertising, this is possible, but this should be clearly labeled as political advertising. So, and also there should be the possibility to allow journalists, researchers, but also citizens in general to monitor political campaign. And restrictions shall be possible, but based on the principle of legality, on clear reason, and on the possibility of judicial review. So just to conclude, I would say that the EU may regulate hidden manipulation, but it should not regulate political opinion as such. So it's okay to be firm against foreign interference, opaque targeting, but we should also be careful not to weaken pluralism or democratic debate.
Thank
All
you.
right. So, since we're moving towards geopolitics and election interferences, I'd like to talk about the geopolitical competition of the European Union. So, for example, if we look at the United States, they've always been big producer of technologies and in general digital services, and they have always basically repealed the idea of regulating that specific market, most likely because they didn't want to harm innovation and development. Now, invoking their constitutional rights, such as, for example, the first amendment of the Bill of Rights, these elites have always managed to keep the Silicon Valley out of the reach of the federal government and federal regulation. However, in the last years, we've seen a bit of a shift in another direction in this dimension. For example, if we look at the TikTok case, it began with Biden, and then it was carried on by Trump as well, with the obscuring and then the acquiring of TikTok in late November 2025. Now, the thing is, the United States have always been against regulation. However, with TikTok, they decided to regulate pretty heavily the market. So are the United States open to regulating the digital markets only if this serves their geopolitical purposes and only if it harms their geopolitical rivals?
Okay, thank you for this question. Here, I think that it's true that there has been a change in the approach of the United States, but we should be careful not to overstate this change, which is real and which exists. What I want to point out is that it's not the United States that just decided to abandon its traditional suspicion that you mentioned towards the regulation of free speech and towards the regulation of markets. This is a tradition of the US. This is still very strong, both culturally and constitutionally. The First Amendment remains a very strong limit to public intervention in the digital sphere. But we have the TikTok case, as you said, and it shows that when technology is framed as a matter of national security, of geopolitical competition, then yes, the United States is willing to intervene much more aggressively, I would say, in digital markets. For many years, the US model was a very permissive approach towards the Silicon Valley, and even the scandals like Cambridge Analytica, they did not push the US to adopt a very strong, comprehensive federal framework, nothing that can be compared to the GDPR, to the DSA, to the DMA, or not even, of course, to the AI Act. So the logic remained: innovation first, market freedom, limited government intervention, and strong constitutional protection of expression. However, why is TikTok different? Because TikTok is not primarily concerned with consumer protection, not at all with data protection, or not even with platform accountability in general. The issue in TikTok was Chinese ownership, access to data, algorithmic influence, and the possibility that a foreign adversary, because China is considered to be a foreign adversary by the US, could use a digital platform, actually a major digital platform, because we have many subscribers in TikTok, as a tool for political or informational power. And this is why the legal framework that has been adopted by the Congress under the Biden administration, I refer to the Protecting Americans from Foreign Adversary Control Application Act, which is a statute, a federal statute. This was a sale or ban mechanism. So, of course, it did not address all platforms equally. It addressed those platforms controlled by foreign adversary, and it required, in that specific case, that TikTok's operations were separated from ByteDance when acting in the US, or otherwise just faced exclusion from the US market. The Supreme Court has upheld that law in 2025, and it has accepted that national security concerns may justify very strong intervention, despite the fact that TikTok and ByteDance, they were raising First Amendment concerns based on the US tradition. So TikTok is not traditional market regulation, it's more geopolitical regulation of technology, because technology here is no longer just a private market or space for innovation. It's more treated, we may say, like a strategic infrastructure, so a place where the data, the attention, and public opinion and national security, they all converge together. And this also explains another interesting thing, which is the convergence between the Biden and the Trump administration, because we know that started with Trump, then continued by Biden, and then again by Trump. The Trump and the Biden administration, of course, they are very different politically, but they both, in different way, but they both accepted that TikTok raised a strategic problem because of their connection to China. So the solution evolved from an executive order with Trump to a law with Biden to other executive orders with Trump. And at the end of the day, TikTok has announced the creation of a US-controlled joint venture with ByteDance, so the Chinese company, retaining just a minority stake, which is below 20%. So at the same time, all of this is true, but I would like to reinforce the idea that this is not necessarily a permanent transformation, and we need to keep it very separated from the regulatory model of the European Union, because there is no specific constitutional theory on platform regulation. There is not a comprehensive right-driven framework like we have in the European Union. I would define the TikTok choices as a selective model, because in general, the US tend to resist regulation if the issues are market power, data protection, platform governance, but it becomes really interventionist when the issue is framed like a national security issue. So my idea is the TikTok case does reveal a change, but it's a targeted and a geopolitical change, not at all a full conversion, of course, in the European style regulation. We may say that in this regard, we don't have a very strong Brussels effect because the US is culturally and constitutionally resistant to broad regulation of the market. The thing is that the market can be perceived as instruments of foreign influence. So generally, the market is the default rule. National security is the exception, but TikTok shows us that the exception may become increasingly important.
So basically what the United States are saying is that data breaches are okay if they are within the country. So if it's Cambridge Analytica, it's fine, but if it's ByteDance, then it becomes a national security problem. And citizens actually believe that. That's what puzzles me, at least. I think that as an American, I wouldn't be so happy with such data breaches, for example, the Cambridge Analytica and Meta case inside the country. And I mean, not less than I would be with ByteDance, but since the law has passed and so representatives of the people actually voted for it, it seems like Americans are okay with this model. Is it because of, I don't know, market expansion? Is it a money-driven model? Is that what differentiates it from the European vision?
Well, for sure, it's because of a certain conception of a market, the market that innovates, that market that allows more and more research in order to gain more and more power. But also, I do think that this depends on a certain very different vision of privacy than the vision that we have in the European Union. We may say that in the European Union, yes, privacy is a fundamental right. Also, privacy can be balanced with other rights. While in the US, let's say that privacy tends to be privacy, and I also refer to data protection, which is related to privacy. They are totally, let's say, I wouldn't say totally recessive, but they are often overwhelmed by other issues. So we have this idea that the Fourth Amendment, which is the constitutional provision from which privacy rights stems, they can be balanced a lot against other relevant interests, be it national security, public safety, and things like that. We have that idea, which is a very strong doctrine of the US Supreme Court, which is the third party doctrine. So the idea is that when you give your data to someone, be it a company, a bank, or anything else, you are practically renouncing to the privacy of that data. You are accepting that that data may be used in some way. In Europe, we have a totally different conception, because if you give your data, I don't know, for example, for university, for research, for other services, those data shall not be used for other purposes. So I would say it's a cultural difference, but it's also very based on the idea of a prevailing market and an idea that at the end of the day, data is an asset of the market.
Thank you.
The AI race is more actual than ever, with both American and Chinese firms competing in the creation of new systems and the application of those in various sectors. In this context, the EU seems once again to be cut out of the innovation competition, as happened with the internet economy. Do you think that EU still has a chance to develop its own AI industry, even with this layering of regulations and directives that in some way limit innovation?
Okay, well, here I would take quite a clear position, because I do not think that the EU is just giving up on innovation. The real question in my view is what kind of innovation model the European Union wants to build. I wouldn't say it's just cut out of the AI race. It is true, of course, that the largest AI companies, especially if you think of generative AI and other frontier models, they're mainly American or Chinese. And it's also true that Europe has traditionally been stronger in regulation than in creating and scaling digital champions. And this was one of the key concerns, for example, of the Draghi report on European competitiveness, which identifies the innovation gap as one of Europe's structural weaknesses. But I don't think that the conclusion is, okay, the European Union has to choose between regulation and innovation, because that would be too simplistic. The EU shall try, and maybe is trying, to develop a different model, which is not based on innovation at any cost, but it's a model based on trust. It's a model based on which innovation shall be trustworthy, right-based, and industrially sustainable. The act which is central here, in my opinion, is the AI Act, because the AI Act, it creates obligations, and some of these obligations, they may be burdensome if you put yourself in the shoes of a company, especially if you are a small firm. But the logic under the AI Act is not totally to prohibit. It's to base things on the risk that they represent. We have unacceptable risk systems and they're just prohibited. Then we have high risk systems, they are strongly regulated. And then we have lower risk systems, they are either non-regulated or very lightly regulated. So the idea is not that we want to block innovation. The idea is that AI exists and we must create legal certainty and trust around the AI environment. And I would like to highlight that also trust can be an economic asset. Think of sectors, for example, like health, but also finance, public administration, education, or critical infrastructures. In those sectors, AI will not be adopted unless citizens, companies, public authorities, they trust that these systems are safe, they are explainable, non-discriminatory, and also accountable. So, of course, this kind of regulation, they necessarily slow down some forms of experimentation, but it can also make, if they work correctly, if they are implemented correctly, the deployment of AI tools more legitimate and more stable, I would say. So, Europe shall not deregulate everything, but Europe shall try to close the innovation gap, to mobilize investment. Also, of course, if regulation is excessive, to simplify regulation, because this helps companies grow, this helps the market being more open. So I wouldn't say the problem is regulation as such. The problem is when regulation becomes fragmented, when it's implemented slowly, when capital market is not sufficient, or we have weak industrial coordination. There have been recent initiatives, for example, Invest AI, with the objective of mobilizing billions of euros in AI investment, including funds for AI new factories, and these are very important. So they show that the EU knows that regulation alone is not enough. We need infrastructure, we need data access, and we need an industrial policy. So my answer would be yes, the EU still has a chance, but not if it just relies on regulation. We need an innovation ecosystem, so less fragmentation, faster authorization procedures, more venture capital as well, more also public procurement of AI solutions, and sometimes also better links, stronger links between university, research centers, and industry in the field of AI. So I would resist the idea that EU regulation just limits innovation. Yes, sometimes it does. Sometimes instead it channels innovation in safer ways and into more socially acceptable and rights-driven applications. So regulation should be predictable, proportionate, and also innovation-friendly. So if we look at this in comparative constitutional terms, the bet of the EU is this, because we have the United States, which is largely driven by strong private technology power. We have China, which is state-led technology innovator, while Europe is trying to build a model in which innovation is compatible with human rights, with democratic oversight, and with market fairness. Of course, as any time that you try something, the success of this model is not guaranteed. But I don't think that the EU is out of race. So the idea is more to make the regulatory power compatible with industrial and technological power.
Thank you very much.
Thank
Very
you.
interesting points.
Yeah. So now we were talking about China, which is a very interesting topic, I would say, because right now, actually, a few days ago, on the 28th of May, 2026, the European Commission issued a fine to Temu, large e-commerce platform, for 200 million euros. And the motives stated by the Commission is that Temu failed to identify, analyze, and assess the systemic risk of illegal products being offered on its platform, resulting in possible harm to consumers inside the European Union. Now, who is Temu first? Temu is a company founded in 2022 in Boston, Massachusetts, United States. So it's actually an American company on papers, but actually it is part of a bigger holding, which is PDD holding, which is one of the biggest holdings in China. So it is basically a mixed creature between American and Chinese, which for the European Union represents quite a problem. So what does this whole case tells us about the role of the European Commission inside European regulation? Is the European Commission going towards being an enforcement body? What is its supervision role inside the Digital Services Act? Could this case be read as an evidence of the growing regulatory power of the European Union on digital platforms, also if they're not from the European Union itself? And what are the constitutional matters, constitutional questions that are risen by this case in terms of accountability, but also in terms of due processes, in terms of market governance as well? So that is kind of a broad question, but...
Sure. No, thank you. It's an interesting question, because I think that the Temu case is important because it shows us that the Digital Services Act, the DSA, is not just a framework on paper, it's becoming a very strong enforcement tool. And another important thing is that Temu is not just a traditional social network. As you said, it's like an online marketplace. So the case shows that the DSA, it's not just about speech, content moderation, or disinformation, but it also protects consumers, product safety, platform design, and also how they manage their systemic risk. For sure, the Temu case confirms the evolution of the European Commission into a very direct supervisor of very large online platforms. Because under the DSA, the Commission is not just setting general rules and leaving enforcement to member states. At least for very large online platform and for very large online search engines, the Commission is showing to have direct investigative and also sanctioning powers. And this is a significant constitutional development, because here the Commission is acting like a European regulatory authority for the digital public sphere and for the digital market. The Commission, we saw in this case, it can request information, assess compliance systems, evaluate risk assessment, impose fines, as you said, and also require changes in the behavior of platforms. So yes, I would say that the case can be read as an evidence that the EU is making the Commission's regulatory power grow, and especially when we are talking about global digital platforms. So we can say also that this case is interesting because we say that the EU is using access to the internal market as a regulatory lever. So it's like trying to reinforce its Brussels effect that sometimes we shall not overstate. Brussels effect means that if you're a company and you want to operate in Europe, you must comply with European standards of transparency, risk assessment, consumer protection, and fundamental rights. Otherwise, there is no point for you in operating in Europe. You will be sanctioned. Sometimes this effect works, sometimes it does not. With the role of the Commission based on the DSA architecture, I think that they are like trying to reinforce that effect. So yes, the EU is like trying to build more on its regulatory governance, but still there are serious constitutional questions, because the first question that I see from the perspective of a comparative constitutional lawyer is accountability. Because if the Commission becomes a strong central supervisor of platforms, then we must ask ourselves, how is its discretion controlled? Because these are not just minor administrative decisions, they affect the way in which global companies work, how millions of users use those services, and how digital markets are structured. The second point that I see here is due process, because platform must have the right to know which allegations are against them, how to respond, how to access evidence, and how to challenge the sanction before the courts. This is essential in my view because the DSA involves very high fines and also very intrusive obligation even in corporate structures. And the third point, which is linked to this, is market governance. Here, the EU is not just correcting individual violation by a certain company. It's shaping how the platforms are needed to organize their compliance system, their recommendation system, how they control their product, and how they frame their risk management procedures. And so this means that public regulation is entering very deeply into the architecture of the business model of digital companies. So I would say that the Temu case is interesting because it both illustrates the strengths and the risks of the European approach. The strength is that the EU is trying to make itself stronger. It does no longer depend on voluntary commitments of platform like it was some years ago. It can impose legal duties and it can enforce them, sometimes even extraterritorially. The risk is that the Commission takes a very broad supervisory role over digital market, and this role can be legitimate. It's the task of the Commission, but it shall remain transparent, proportionate, reviewable, and grounded in clear legal standards. So, in short, what I would say is that the Temu case, which is very recent, shows that the DSA is becoming a real constitutional tool for market governance. It's not just about, let's remove dangerous content. It's about making platforms more responsible for the systemic risk that they create. But precisely for that reason, the enforcement must be joined by strong procedural safeguards and strong judicial control. This is my view.
Thank you. And just to close on this new role of the Commission, is the Commission maybe evolving to face the new geopolitical challenges that we are seeing in this world? I mean, this sanction, sure, it is grounded in evidence. There were illegal products that were sold on Temu, but it also may be seen as a geopolitical tool, a geopolitical competition tool used by the European Commission to undermine Chinese platforms inside the European Union. So something like non-tariff trade barrier, digital trade in this case, barrier. So is the European Commission taking a stronger role, if we could say something like that, like a more executive role inside the European Union, because the European Union needs to undergo a process of federalization and stronger executive power to face United States and China competition?
Well, yes, first of all, I would start by saying that traditionally, and if you look at the general architecture of the European Union, the Commission is conceived like a sort of executive. Of course, we know that we cannot transpose the constitutional categories that we use to study domestic states to the EU, but if we try to do so, we can say that to some extent, we often say a bit simplistically that the Commission is the executive of the European Union. For sure, that executive role is reinforcing, and I may see here also a certain will of geopolitical imposition, because as you said, we have those global geopolitical actors, which are basically China, the United States, and the European Union. China has its own model, which is peculiar, which is state-driven, and which could not be accepted in an open market economy like the European Union is. The United States, on the other hand, it's like leveraging a lot on geopolitical consideration, and on its side, I think that the European Union also is reacting. So yes, I see a certain geopolitical driver behind this approach of the Commission, but also I see a certain geopolitical driver behind the legislation that exists in the European Union. Also because if you think about it, yes, the European Union has a rights-driven model when we think about the regulation of the digital sphere, but we shall also consider that the European Union was born as an institution to regulate competition, to ensure fair competition, and to ensure open markets. So to some extent, the European Union is going back and is renovating its role with which it was born.
Thank you so much.
Thanks, really.
So that is all for today. Thank you again for the speech.
Thank you both.
And see you to the next episode of Voices of CIVICA. Thank you.
Thank you.